Stream has started.
Good morning, ladies and gentlemen. This is the hearing of the Utah Board of Oil, Gas, and Mining for February the 24th, 2016 in the DNR building, auditorium, Salt Lake City. Our first agenda item is docket number 2016-001, cause number 187-11 in the matter of QEP Energy Company. We'll take appearances at this time.
Hi, Mr. Chairman. Mark Burkhart with S+&H for QEP Energy Company.
John Robinson, Utah Attorney General's Office, representing the hearing examiner today.
Any others? Mr. Burkhart, please proceed.
Mr. Chairman, we held a hearing on January 19th, 2016, where we presented our facts and gave testimony and other evidence to the hearing examiner. And I believe that the hearing examiner has submitted those proposed findings of fact and conclusions of law. And based on that submittal, and I think a presentation that he's going to give here in a few moments, we ask that the request for agency action be approved, that those findings of fact and conclusions of law be adopted.
Thank you. Mr. Robinson.
Mr. Chairman, with the board's permission, I'll turn the time over to Mr. Rogers to my left, your right, and to make his short presentation about those proposed findings and conclusions.
Thank you.
Chairman Gill, members of the board. As was stated, I was asked to be the hearing officer for this matter for QEP. The hearing was taking place on January 19th, 2016. It was through a video conference. Mark Burkhart, counsel for QEP, was present in our office here, and we heard testimony from representatives from QEP over video conferencing. The subject lands are part of the South Redwash Exploratory Unit, and it's administered by the BLM. It's approximately 15,382 acres. QEP is the unit operator. The subject lands have not been spaced by the board and are being developed through general siting rule, which is Utah Administrative Code R6493-2. Essentially, this says that wells must be placed within a 400-foot window of a 40-acre governmental quarter section. This is approximately 40-acre spacing, but not a true spacing. QEP stated that there are proposed additional 343 wells, of which 32 would need exception locations. Therefore, they'd have to go through the process of getting those. So through their presentation and through their testimony, we looked at that, and I, as a hearing officer, agreed to suspend the rules as they requested in their request for agency action, and develop the rules, develop the field continually under the general agreement of the Federal Exploratory Unit. So I support their request for this agency action.
Thank you very much. Back to you, Mr. Burkhart, and then I'm going to go to the board. Any response to that?
Yes, Mr. Chairman, I have nothing to add other than to thank the division and the board for allowing us to conduct this hearing via video conference and taking the time to hear this evidence with the hearing examiner, in particular, Mr. Rogers. We appreciate his time.
Okay, any questions from the board members? I have one question, just Mr. Rogers, about how the electronic hearing went from your perspective, using the electronic hearing method.
It's always improving, and through Paul Gage's efforts, it was seamless, and it's becoming very effective.
Thank you very much. The board members, then the a motion is in order to approve the request for agency action as submitted by the hearing examiner. Is there a motion in that matter?
So moved.
So moved. Is there a second?
Second.
Any discussion? The motion before you is to approve the request for agency action as submitted by the hearing examiner. All in favor say aye. Aye. Any opposed? So passes. Thank you very much. Let the record show that that was unanimous. Mr. Burkhart, you have the order. I think it's been, I guess at this point, procedurally, it's been approved now and needs a signature. Is that correct?
Well, Mr. Chairman, it is a proposed findings of fact and conclusions of law, so I can draft and expand that to include an order and submit that to the board if
you would.
You would like. Thank you.
Yes. Thank you.
Thank you for your time.
Thank you.
The second agenda item is docket number 2016-002, cause number 166-07, in the matter of Fidelity Exploration and Production Company. We'll take appearances of counsel at this time.
Fred McDonald of McDonald & Miller on behalf of petitioner Fidelity Exploration and Production Company.
Steve Alder with the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Any others? Seeing none, Mr. McDonald.
Thank you, Mr. Chairman. With me today testifying on behalf of Fidelity are Ms. Lori Turr, Senior Landman, Mr. Dave List, who's the consulting geologist, and Mr. Mike Morrison, who's the operations manager. I would ask that they be sworn in as witnesses at this time.
Right hands. You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Mr. McDonald.
Thank you, Mr. Chairman. The resumes of all three witnesses were submitted as part of Exhibit A in this cause. Ms. Turr will be testifying as a fact witness only. Mr. List has been qualified and recognized as an expert in geology before this board in cause number 166-06 last October. Although, as reflected by his resume, he is an experienced petroleum engineer, Mr. Morrison is appearing before this board for the first time. If separately and individually asked about the contents of their respective resumes, the witnesses would confirm the same. Based on Exhibit A and with the presumed stipulation of the division, I would request that Mr. List again be recognized as an expert in geology for purposes of this cause at this time.
Yes, no objection.
And then pursuant to Mr. Alder's standing request, I will qualify Mr. Morrison as an expert in petroleum engineering for purposes of this cause at the commencement of his testimony.
Thank you.
All right. Mr. Chairman, I would like to point out and apologize for a typo that appeared in the caption of this matter that was filed. The caption refers to lands as the southeast quarter of Section 25. It is properly Section 35. The body of the request for agency action and, more importantly, the notice of the hearing both correctly describe the land, so it was just a typographical error. It should be a harmless error and it shouldn't have caused any prejudice to this matter, but I did want to have the record clarified.
So clarified, and let's amend that to be the appropriate Section 35.
Thank you, Mr. Chairman. Also, I want to confirm that the board received the supplement to Exhibit Z, which were just the additional mailing receipts that were received after the filing date for the exhibits.
Yes, we did.
Okay, and finally, Mr. Chairman, as with your practice, I will be moving for admission of the exhibits at the end of our presentation in chief.
That's our preference.
Thank you, Mr. Chairman. Members of the board, as the board is aware, Fidelity is the operator of the Cane Creek Federal Unit located west of Moab and north of Dead Horse Point. All depths and formations are unitized, and there are currently two separate participating areas in the unit, the largest being the third revision to the second consolidated paradox formation, which I will be referring to hereafter as the existing PA. In May of 2014, Fidelity spud the Cane Creek Unit 36-2-25-19 well and drilled it horizontally in anticipation of oil production from various clastics in the paradox formation. The well was completed as a producing oil well with first production on August 26, 2014. However, the well does not meet the unit paying quantities definition contained in the governing unit agreement. The lateral of the horizontal well traverses lands both within and outside of the existing participating area. However, with the well being deemed a non-unit paying quantities well, the existing participating area could not be expanded to include such lands until such time, if ever, the well meets the paying quantities criteria. Under such circumstances, BLM regulations and guidelines require communitization, under which the agreement is to allocate production on a pro rata acreage basis to the leaseholds outside of the existing participating area and to the production interest owners in the entire participating area via the unit agreement. It's a contractual relationship that causes that allocation to everybody within the participating area. However, the BLM will not approve a communitization agreement without a conforming spacing order from the board. The reason Fidelity is before you today requesting the creation of a special drilling unit for this particular well. It is important to note that the general horizontal drilling rules, and in particular the rules establishing a temporary 640-acre drilling unit for horizontal wells, do not apply with lands within a federal unit pursuant to the division's rules R649 3-2 subparagraph 8. As the board is already aware from the hearing in October, and as the testimony and evidence offered today will again reflect, the Paradox Formation is a complex conglomerate of resource-bearing clastics interbedded with salts. Due to these complications, the BLM, as administrator of the unit, consolidated the entire formation for purposes of the existing participating area. For similar reasons, Fidelity believes the entire Paradox Formation constitutes one common source of supply. In addition, Fidelity and the BLM have agreed, based on the same testimony exhibits, that the appropriate drilling unit should be the lands outlined in the request, with a 760-foot setback from other wells both laterally and vertically. Fidelity is confident no lands beyond those being requested for inclusion in the drilling unit are being drained by the well. Fidelity is also requesting that should the well ever produce in unit paying quantities such that all of the requested drilling unit lands are otherwise brought into the unit participating area, the requested drilling unit, if approved, will be suspended, the conforming communitization agreement terminated, and the unit agreement will govern the production allocation pursuant to a revised participating area. The board has jurisdiction over this matter pursuant to Utah Code annotated sections 40-6-5, subparagraph 3b, and 40-6-6, subparagraph 6. The request was sent via certified mail, return receipt requested, to the BLM, both at the state office and the Moab district office level, as the governing agency and as an oil and gas owner, and to all of the production interest owners in the leases covering both the lands outside of the PA and in the entire participating area, to their last addresses as disclosed by a search of the BLM, SITLA, and Grand County Realty records. Fidelity is the sole operating rights owner of the Paradox Formation as relevant to this request. Notice of the request and of this hearing was also published in the Moab Times Independent on February 3rd, 2016, and the Salt Lake Tribune and Deseret Morning News on February 7th, 2016. The Utah State Office of the BLM timely filed a letter with the board on February 8th, 2016, expressing its support for the granting of the request. That letter should already be deemed part of the record, but to the extent it's not, I would ask that the board include it as part of the record for purposes of this cause.
We did receive that, and it's so included.
Thank you. No other objections or responses were filed, and the division elected not to submit a staff memorandum in this cause. With that, I'll commence my examination of Ms. Tur. Ms. Tur, would you
Hang
please?
on just 1 second.
Sure.
In the interest of time, because this is, we're aware of this Cane Creek unit, the matter, if there's anything you can proffer to expedite this particular matter, we would appreciate it. I don't know if you can, but if you would consider that for just a minute.
Certainly, I will do everything in my power, and as long as Mr. Alder would agree with the proffer.
Do you have any objections to that?
No, I have no objections. I believe the matter's fairly straightforward, but however he chooses to go ahead, we will certainly cooperate.
Okay, thank you.
Ms. Tur, would you please state your name and business address for the record?
Yes, Laurie Tour, 1801 California Street, Denver, 80202.
And what is your current position with Fidelity?
Senior landman, responsible for the Paradox area, specifically the Cane Creek unit.
Mr. Chairman, I would proffer that Fidelity is duly qualified to conduct business. You've heard that in several matters. Ms. Tur would also testify to that, so if we could skip that then.
Please do.
Okay. And also the board is familiar with the Cane Creek unit formation, all that, so I'll skip over that. And that Fidelity serves as the unit operator. I'll proffer those. Ms. Tur, I'm now going to direct your attention what have been marked as exhibits B, C, and L for purposes of this hearing. If you look over here, do you recognize these documents? And were they prepared by Fidelity personnel with your review and input?
Yes.
Okay. Turning your attention to Exhibit B, which is shown on the PowerPoint, this is just a reference map. Would you just explain to the board what everything is represented on here?
Sure. Yes, in the red outline is the Cane Creek unit boundary. There are two separate PAs, the smaller PA up to the northwest. The larger PA is the second consolidated Paradox PA. It's in its third revision. The blue outline is the spacing unit that we're here to talk about today. As you know, the Cane Creek unit it's west of Moab and north of the state park.
Okay, now directing your attention to Exhibit C1, please explain what this exhibit represents.
This also is kind of a zoom in of what you just saw. The yellow outline is the largest of the PAs. The blue outline is the spacing unit that we're here to talk about today. The well, the 36-2-2519, the surface hole location is up to the northwest. The bottom hole location is to the southeast.
And could you point out what the significance of that light blue shaded area within the proposed drilling unit is?
Yes, those are the 3 federal leases that are outside of the participating area, which we propose to space.
Okay, now directing your attention to Exhibit L, just explain to the board what this represents.
Another zoom in. So basically, the blue line represents the proposed drilling and spacing unit, and then the horizontal 36-2, the surface hole location up to the northwest, and the bottom hole location down to the southeast.
And again, the blue shaded area is the area that's outside of the existing participating area?
Correct. Yeah, we have 3 federal leases.
Now I'm going to direct your attention to Exhibit C2. There is no PowerPoint relating to this. Could you please explain what this is?
Sure, yeah. This is the title takeoff that was done by Vern Jones. He did a search of the BLM records, and then that's Vern's.
And then also, does it? There's a spreadsheet about the participating area.
Right. This comes from the Fidelity record. So this is our revenue deck that shows all the working interest and royalty and overriding royalty interest owners within the existing PA.
So these are all the parties to which the production from this well would be allocated. Is that correct?
Correct.
All right. And can you confirm that Fidelity is the only operating rights owner in the Paradox formation that's sought to be spaced here?
Yes, that's correct.
Okay. Could you please briefly outline for the board the history of the well, when it was drilled, first production, etc.?
Let's see. It was first spud on May the 12th, 2014, drilled horizontally through the Paradox Formation clastics, and completed as an oil well with first production achieved August the 26th of 2014.
Okay, now I'm going to direct your attention to what has been marked as Exhibit D. It's right here. Again, there's no PowerPoint. Do you recognize this letter?
I do, yes. We received it from the BLM, dated October the 6th.
Of 2015?
Yes.
And this is an official business record of Fidelity, is that correct?
It is.
Okay, can you just kind of outline what this letter states?
Yes, it was the letter from the BLM stating that thank you. Stating that the 36-2 was deemed a non-paying well.
And did the BLM request certain action of Fidelity with respect to that then?
They did, yeah. They requested that we come before the board, the division, and get a spacing order so that we could therefore communitize the lands.
And that communization is required again because the well has portions inside and outside of the unit. Is that
That's
correct?
correct, yeah. 3 separate federal leases outside of the existing PA, and then the participating area.
Hey, is it your understanding that the BLM guidelines require that communization agreement correspond with the date of first production of the well?
Correct.
Can you confirm for the board that Fidelity will retroactively pay production proceeds on the basis ordered by the board?
Yes.
Right.
We
Can you
will.
also confirm Fidelity's request that if the well ever did meet the paying quantities requirements, or the lands were all included in the participating area, that you would want a suspension of the order and the CA terminated and then let the unit agreement govern?
Yes.
Now I'm going to show you what has been the marked or a pleading that's on file that was prepared by my office entitled Certificate of Service. Do you recognize the names and addresses shown on those?
Yes, they were those that we found through our title search, both at the BLM and the county level.
So these are the same parties that were shown on Exhibit C2 as well. Is that correct?
Yes.
All right. Mr. Chairman, the Exhibit C is supplemented as a true and correct copy of all the return receipts or the return mailings received by my office, reflecting the receipt of the request for agency action.
Thank you.
With that, that concludes my examination of Ms. Tur.
Mr. Alder?
No, that was, I believe those were received on the same date.
We didn't hear your question for the record, Mr. Alder.
And I apologize. I just actually wanted just to clarify something with Mr. McDonald before I decided whether cross-examination was necessary.
Thank you.
Oh, I apologize. Yes, what Mr. Alder is referring to is a second letter that was attached to the BLM's letter in support dated February 4th, or it was received on the 8th. And the letter, if I could show this to, and we probably need to mark this as an exhibit, or if it's part of the record, it's the BLM's letter in support. There's a second letter dated January 20th, 2016. Ms. Tur, would you please address that per Mr. Alder's request?
This is the letter from the BLM dated January the 20th, 2016, where they established this third revision of the second consolidated paradox formation PA, which happened after the request for agency action, correct?
Yes.
Yeah.
So in other words, what happened is there was a revision for the participating area after the filing of the request, and now there's an additional revision to the PA.
Yeah, 1,000 acres were added via this revision.
But the only practical effect of that would be is that the allocation amongst the participating area owners from this particular well would be based on that revision.
That's correct.
Let's call the the original October 6th letter Exhibit D-1, and this will be D-2. D-2 being the January 20th, 2016 third revision of the PA.
Thank you. And so in light of that testimony, are the exhibits C2 and C2 that you talked about earlier, are those accurate? The allocations of production that are shown on Exhibit C?
Yes. They reflect the current participating area, the third revision of the second consolidated paradox.
Thank you. And then just one question further, Mr. Chairman. Looking at Exhibit L, which is on the screen, just to be clear about your testimony, the drilling unit that is requested is the area inside of the dark blue line, is that correct?
That's correct.
And so the shaded blue line is a portion of the drilling unit or requested area.
Yes, that's correct. Yeah, the shaded blue are the federal leases that are contributing.
But the entire area within the larger outline is the area that is subject to the board's action today.
That's correct. That's the full 510.4 acres.
Thank you. No other questions, Mr. Chairman.
Board members? Seeing none, back to you, Mr. McDonald.
All right, Mr. Chairman, at this time, I would call Mr. List to come and testify. There's only one exhibit, but his testimony is going to be essentially the same regarding the paradox formation as was heard in October.
You can call him, but if you want to make a proffer on that, that would be appreciated.
Okay. Well, I would proffer that Mr. List would again testify similar characteristics of the paradox formation. The only difference would be is Exhibit E is a slightly different log for which the stratigraphic definition is done for here. But his expert testimony would be is that essentially that the paradox formation constitutes a common source of supply for oil and associated gas and hydrocarbons with compartmentalization that is difficult to predict. And if you'd like, Mr. List, is that a fair summary of what your testimony would be?
Yes, it is.
No objection to that proffer.
Okay. Any questions from the board on that? Thank you. Move to your next witness.
Mr. Morrison?
And let's just note that that was Exhibit E that we were talking about.
Exhibit E is the slightly different exhibit with the log for this particular well.
Correct.
But the other exhibits are similar, if not identical, to the ones that you heard in October in 16606.
Okay. And now Mr. Morrison.
And Mr. Chairman, if I might, in order to expedite things, I think the only aspect of Mr. Morrison's testimony or resume that would be of interest to the division would be his experience at the Paradox Basin. He has an extensive and very interesting resume of experience all over the world, which be fascinating to hear about, but I don't think we have any other concerns about his ability to be an expert in this matter.
Fine, thank you.
All right, Mr. Morrison, would you first, just for the record, state your name and address, business address?
My name's Michael Morrison. I'm currently employed with Fidelity Exploration and Production Company at 1801 California Street, Suite 2500, Denver, Colorado, 80202.
And what is your current position with Fidelity?
My current position is Operations Manager for the Growth Business Unit, which includes the Paradox Basin and specifically the Cane Creek Unit.
All right, addressing Mr. Alder's question, if you could just address to the board, what has been your experience in the Paradox Basin or analogous basins?
My experience in the Paradox started 2 years ago in March 2014 while I was in Fidelity's Houston office. I became responsible for supporting production, enhancement production activity, artificial lift, just diagnosing well problems at that point. Eventually progressing to operations management in that area, and in October of last year transferred up to Denver in that capacity, which I currently hold. So it's about 2 years.
And at this time, Mr. Chairman, I'd ask the board to recognize Mr. Morrison as an expert in petroleum engineer based on his resume in Exhibit A and that additional testimony.
No objection.
Board members? Seeing none, he'll be so admitted.
Thank you, Mr. Chairman. Mr. Morrison, I'm now going to direct your attention to what has been marked as Exhibits H, I, J, K, and L for purposes of this hearing. Were they prepared by Fidelity personnel with your review and input?
Yes.
And Mr. Chairman, I'm going to go through these because we can go through them pretty quickly, but they're important for the record. Okay, directing your attention now to Exhibit H, please explain what this represents.
This exhibit shows the production history of the 36-2 well, again beginning in August of 2014. Oil production is green, gas in red, and water, which you can see starting to show up about the middle of 2015, which is also when the well ceased to flow naturally and was put on artificial lift.
Okay, directing your attention now to Exhibit I, please explain its significance.
This is another depiction of the production history using monthly rates in a software program that we use for reserve analysis, and shows the projection on the oil production that we've used in establishing the expected ultimate recovery of 209,000 barrels.
Okay, directing your attention now to Exhibit J, would you please explain what this represents?
This exhibit actually shows the calculation that was done to determine the most likely drainage area. It's a calculation that typically proceeds from the top down, knowing the area that we're dealing with. specific rock properties such as the porosity and water saturation, and arriving at the ultimate recovery at the bottom line. In this case, we're starting, in fact, with that ultimate recovery and working backwards using the expected, and calculating the area required to produce that volume. That depends on what we assume for the recovery factor. For instance, starting with our EUR of 2009 barrels, let's assume that represents 12% of the oil contained in the area drained by this well. In other words, a recovery factor of 12%. This equates to 1.7,042,430 stock tank barrels of oil in place. And converting that volume to reservoir barrels using the formation volume factor of 1.34 gives us 2,334,857 barrels of reservoir volume occupied by oil. So taking into account the porosity of 6% and water saturation of 35%, we calculate rock volume of 7,717 acre feet. Dividing this by the reservoir thickness of 60 feet gives us a drainage area of 128.6 acres, represented essentially as a rectangle along the length of the lateral wellbore. So for our lateral length of 3,873 feet, which was in a previous exhibit we skipped over, this means the width of that rectangle is 1,447 feet, or a half length or radius on either side of the lateral of 723.5 feet. Now, if that calculation is done using a different recovery factor, which can be arranged depending on reservoir characteristics, it'll give a different result for the acquired draining area, and that's in the next exhibit.
Okay, now addressing Exhibit K. Please explain that exhibit.
This just shows the relationship of drainage area or half length of the width of the rectangle that I described versus recovery factor. As I said, if we use a 12% recovery factor, we have a drainage area of 129 acres. If we use a recovery factor of 9%, then we require a drainage area of 171 acres to yield that ultimate recovery. So it's dependent on the recovery factor. We believe a reasonable range in this reservoir is 9 to 12%. So the range would be from 129 to 171 acres, corresponding to a width of that rectangle of 1447 to 1929.
And you use this on the basis, that's how the lands were determined based on the 720 acres for including in the drilling unit, is that correct?
Yes.
Okay, and then turning your attention to Exhibit L, can you explain what the circle tangent is in the orange outline?
We are requesting a setback area of 760 feet to encompass all those potential drainage areas that might fall within a reasonable range. So that's depicted by this yellow line around the lateral wellbore. And that area encompasses 194 acres, which would correspond to a recovery factor of about 8.5%.
So you're comfortable that the proposed drilling unit is not going to, or the well's not going to drain outside of the proposed drilling unit, is that correct?
Yes.
All right. Okay, in your expert opinion then, based on the data generated to date, is it your opinion that the proposed drilling unit is not smaller than the maximum area that can be economically and efficiently drained by the well?
Yes.
Okay. Mr. Chairman, that concludes my examination, Mr. Morrison.
Thank you very much, Mr. Alder.
Just one or two, if I could, just Mr. Morrison. So was your testimony then that for the Paradox Basin and specifically this producing area that the recovery factor is a range of 9 to 12%?
We think that's a reasonable range, yes.
And that corresponds to the 700 to 950 foot setback from the well to the area that would be drained, is that?
Correct.
So this, you chose the smaller area. What was the reason for choosing as opposed to something that would be more in the average of the expected drainage area?
We are requesting a setback area just slightly larger to cover, as I said, a reasonable range of recovery factors. That's about an 8.5% recovery factor for that area. That's a most conservative assumption.
So does that give you the largest diameter of the drainage area?
Well, it's, again, approaching from the standpoint that we feel it's sufficiently large that there will be no other lands draining from that area. That's within a reasonable.
Okay.
Speak into the microphone a little closer, please.
All right.
But it is, in fact, the smaller of the recovery area, given the range of 9 to 12%. Not that I'm contesting your expert opinion, I'm just wondering if I understand it correctly. I thought under Exhibit K you said that the width range, the resulting reservoir width that's shown on that exhibit is 1,447 feet to 1,929 feet, which would mean half of that would be the distance out from the wellbore to the area that would be drained. Do I understand that correctly?
Right. Yes, you have that.
725 to 950. So it appears.
What we're requesting is something with a width of about 1,520 reservoir width. Again, which would be about just a little bit to the left of the 9% value on Exhibit K.
All right, and in your expert opinion, that accounts for the recovery from this well and would take in the area that is drained by this well?
We think that's the lowest reasonable recovery factor we might expect, and therefore the largest area that we might expect.
Thank you very much.
Board members, any questions? Yes. Okay.
Is this well bore producing from any other portion of the paradox besides the Cane Creek?
No, it's not.
Okay, back to you then, Mr. McDonald.
Thank you, Mr. Chairman. At this time, I would move for admission of Exhibits A through L, including Exhibit D2 and Z as supplemented.
No objection.
So admitted.
With that, Mr. Chairman, a very brief presentation, but again, I think the board has a clear understanding of why these are needed in connection with the federal regulations. I think the burden of proof has been established in this case, and that we would request that the request be approved as submitted.
Thank you. Just to be clear, we did revise Exhibit D and rename it to D1, and then we added a new exhibit, D2.
D2, correct.
So though all of those exhibits have been admitted, board members, now would be the time for a motion or deliberation. The motion,
Mr. Chairman, if I might first.
Beg your pardon.
I know in these matters where we don't have much of an issue, it seems a little bit unnecessary. But for the record, I'd just like to say two things. First of all, I think the division does support the request and does not intend to offer any witnesses or evidence, but would be appreciated if the board would ask the BLM to address this request, since this seems to be primarily a result of their determinations and an attempt to satisfy their concerns.
Thank you. Mickey, would you mind coming forward and speaking into the mic, please?
Thank you, Mr. Chairman, members of the board. My name is Mickey Coulthard, and I represent the Bureau of Land Management in this matter. I think our letter speaks for itself, but I would be happy to answer any questions that the chairman or the board may have in regard to this matter or the division.
Mr. Elder?
Could you, the letters are a little bit confusing to me. Could you just summarize what has happened and why
Well,
the BLM?
Yeah, I think basically what the problem that that occurs in Utah is that we are a law of capture state until correlative rights have been established. So in an exploratory unit, it is basically operated under the law of capture because nothing is spaced and correlative rights have not been established. So as long as we have a mechanism within the agreement to share revenue, then it would be my interpretation of what's going on is that correlative rights don't need to be established. But when we no longer have that mechanism in place because of the terms of the federal contract, then it is necessary for the state of Utah to basically establish correlative rights. And that is basically, in my opinion, what Fidelity is requesting that you do. A lot of this, is a result of the state rule that exempts everything but horizontal wells, from the interaction of the siting rule, it's very clear that with for a typical horizontal well, there would be a 640 acre siting rule, because I think everybody in Utah acknowledges that the temporary spacing is not a temporary spacing, it's a siting rule, which is another very confusing aspect of current Utah rules that I think would be an excellent, we had the workshop last year, about some of the things that need to be addressed as far as horizontal development goes. Now that we have this great slowdown and everybody has a lot of time on their hands, it might be an excellent idea to revisit that and perhaps make some recommendations to the board that could streamline the process.
If I could follow up, Mr. Chairman.
Please.
So if I understand what you're saying is while there's a participating area determination, then the proceeds from this well are shared based on an agreement, but once the BLM determined that this well would not be included and covered by that agreement, then it was necessary for the board to make the determination as to the drainage from this well.
That's correct. In my interpretation of the contract, that the contract does not anticipate this type of, situation, which is, another discussion that the state of Utah could say is, well, BLM, why don't you fix your unit agreement and make it work better for horizontal wells? And we've tried over the years. We've made some amendments to the unit of language. It would be my position that short of a rulemaking, that the BLM cannot really force an operator to adopt a modification to the exploratory form, as that has been published in the Federal Register as a model form and has undergone rulemaking.
And if the BLM were to subsequently determine that this well is producing in paying quantities, then it would come back under the agreement.
That is what has been requested by Fidelity, and it's not only this well. If another well were to be drilled that would, for whatever reason, perhaps it was completed in a different clastic, and then that were to make these lands eligible for inclusion in the participating area, that would also cause the communitization agreement.
Thank you, Mr. Chairman.
That was helpful. Thank you.
Thank you.
Mr. Alder, anything else?
Nothing else. So the division does support the request.
Cue them back to you, Mr. McDonald. I'm sorry, Mr. Alder and Mr. McDonald, getting ahead of myself.
No problem, Mr. Chairman. With the statement, like we said, we just would ask the board to grant the request as submitted.
Thank you. Board members, would you we can take this under advisement, or we can have a motion at this time to approve the request for agency action as submitted.
I move that we approve the request for agency action as submitted.
Is there a second?
Second.
Any discussion? Seeing none, the motion before you is to approve the request for agency action as submitted. All in favor, say aye.
Aye.
Any opposed? Let the record show that that was unanimous. Thank you very much.
Thank you, Mr. Chairman.
We're now at the third item. Board members, do we need a break or can we just motor on? Okay, the third item, if you're ready, I'll read it in. The third agenda item is docket number 2016-003, cause number S/037/0123, in the matter of the reclamation of an unpermitted mine dealing with Monument Resources, LLC.
Mr. Chairman, it'll just take me 3 minutes to prepare a presentation, if that's all right with the board.
Yes, take the time you need.
All right, thank you, Mr. Chairman. The division is ready to proceed at the board's leisure.
Okay, Julianne? Okay, we'll take appearances of counsel at this time.
John Robinson of the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Any others? Seeing none, Mr. Robinson.
Mr. Chairman, members of the board, thank you again for your time. Appreciate this opportunity. I think it'll be my last appearance today. In the next 30 minutes or so, I plan to do three things. First, I'll offer an opening statement and go over a little bit of the background of the limestone mine and explain the procedural posture of this cause. Second, I will call one witness. To my left is Mr. Mike Bradley. He will help me make out the division's case in chief. And finally, I'll offer summation and ask the board to grant the relief requested in the notice of agency action.
Can we give you 20 minutes?
I can do it in 23, Mr. Chairman.
No, just 20.
Try to be brief.
We'll see what we can do. On that note, for the chairman and the board's information, we do feel that we need to protect the record in this case a little bit more than might otherwise be the case because it's expected that this matter will proceed in the civil courts of Utah.
Understood. Thank you.
Board members, this cause is about cleaning up and reclaiming an unpermitted and illegal mine site in San Juan County, located about 1.3 miles northwest of the town of Mexican Hat. You can see a demonstrative exhibit to my right, your left, and that is also Exhibit A in our exhibit list. This mine is known to the division as the Limestone Mine, and the evidence will show that the operator of the mine, called Monument Resources LLC, has failed and refused to comply with the laws of Utah. The situation has been ongoing since at least 2010, and Mr. Bradley will explain how and in what ways the division sought compliance with the laws of Utah before the division resorted to this enforcement action. The other point I'd like to make in opening concerns the procedural posture of this cause. As you know, the division is not seeking bond forfeiture in this action, as would often be the case. Here, Monument Resources never posted a surety of any sort, so there's nothing to forfeit. Therefore, the division is asking the board to order authorization for the division to undertake reclamation efforts on behalf of the citizens of Utah, and then to recoup those costs along with a substantial civil penalty through a second action in civil court. The board has authority to order reclamation cost recovery under Utah Administrative Code Rule 647-3-112. That's also referenced in paragraph 5 of the division's notice of agency action. The second component of the relief requested involves that civil penalty that I just spoke about, and that's in the amount of $22,500. That penalty accrued automatically under Utah law when Monument Resources failed to abate a cessation order issued by the division. That rule of law is codified at Utah Code, 40-8-9.1, and also in the Administrative Code Rule 647-7-103. That authority also allows the board to authorize recovery of the penalties in civil district court as well as the cost recovery for reclamation itself. Monument Resources LLC did not file a response to the division's notice of agency action, and as far as we can tell, they are not represented by an attorney here today. Therefore, Mr. Chairman, the division moves the board to hold Monument Resources in default under Rule 641-104-150.
Board members?
I don't find in the record what they were mining. What were they mining?
Limestone.
Okay, limestone.
Yes, the testimony will show that this is a limestone mine, and the original notice of agency action, for your information, Board Member Davis, is at Exhibit F, and we will get to that in due course and establish the record on that point.
The motion to hold Monument Resources in default is granted.
Thank you, Mr. Chairman. With that, I'd like to move on and briefly present the division's case in chief. As I mentioned, we are interested in protecting the record, and we will try to get this done in 15 minutes. The prima facie case should be fairly easy. At this time, I'd ask that Mr. Mike Bradley be sworn as a fact witness.
Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, thank you. I will now commence my examination of Mr. Bradley. Mr. Bradley, please state your name and position for the record, and if you would briefly describe your duties.
My name is Michael P. Bradley. I'm a lead inspector for the Division of Oil, Gas, and Mining Minerals Resources, Minerals Program, sorry. My duties involve doing mine inspections, permit reviews, compliance enforcement, and provide assistance to operators as needed.
Thank you. I'd like to discuss three things with you today, just so you know where we're going. First, I'd like to discuss the foundation of your knowledge with regards to this mine site and this cause. Second, I'd like you to help me provide an overview to the board of the limestone mine site itself. And finally, third, I'll have you provide some explanation of the exhibits. On that first point, would you please explain to the board what the basis for your testimony today is?
I am assigned as lead inspector for Grand, San Juan, and Weber counties. And as being part of my area of responsibility, San Juan County, I am responsible for inspecting mines in that area. I've reviewed the file on this mine. I've actually reviewed all the files on this in San Juan County, and I have been to the mine site itself 3 times.
All right, thank you. Let me turn your attention to Exhibit A. Using A as a reference, please give the board a brief overview of the mine site itself and the current conditions there.
Okay, in Exhibit A, you can see a broad yellow outline around the disturbed area. To the northwest of that area is a staging area, loadout area, and sorting area. You can see heavy equipment located in that area in this aerial photograph taken in 2014. In the lower section of the yellow outline, you see some collateral disturbance. It was just some bladed ground and some stockpiled rock. And then the dashed line running basically diagonally down the center of the outlined area, to the right of that or to the east of that line is the actual excavation area involved. The total disturbed area is about 3.7 acres.
Thank you. Mr. Bradley, let's move on through the rest of the exhibits. I think I'm going to skip over at least one in the interest of time, so don't be taken aback on that. On Exhibit B, please explain to the board what this email is and how it's relevant to this cause.
Exhibit B, maybe I should step back a little bit. I came on board with the division in 2013. My predecessor was Tom Munson, who was lead inspector for this area previously. This email is an email from Tom Munson to Brooke Hedleston of Monument Resources. Brooke is the office manager for the company down in Bluff, Utah. As you can see, the email is dated December 8th, 2010. So this indicates that as early as 2010, this operation knew that they needed to get a permit and was informed that they needed to have a permit.
All right, thank you.
I think that's it, yeah.
Let's move on to Exhibit C. Could you explain to the board this exhibit?
Okay, in Exhibit C, as part of my getting familiarized with my duties, I reviewed all the files in San Juan County, and then later in the year tried to conduct an inspection tour to get to every site that I could and familiarize myself with the locations in San Juan County. As such, when conducting an inspection of a site, you write up an inspection report, and this is that report.
And would you explain to the board the gap between 2010 and 2013? Is that the transition between Mr. Munson and yourself?
That is the transition between Mr. Munson and myself. I believe Tom Munson left the division in January of 2013, and I came on board in May of 2013. What the gap was between 2010 and 2013, Mr. Munson's departure at that time, I really can't explain that. So.
All right, thank you. Let's turn to Exhibit D. You also see in the back of Exhibit C, these pictures were also part of your inspection report. Is
Right.
that correct?
These are part of the photo log that we document the site with.
All right, thank you. And then on Exhibit D, this is Division Directive from July 2014. Please explain to the board this exhibit.
After reviewing the file and seeing the minimal contact that was conducted with Monument Resources previously, one being the email from Tom Munson previously cited, and plus a few little post-it notes with phone numbers and such between Tom Munson and the operator, I decided to reinitiate contact with this operation down in Bluff by sending a division directive. The goal of this division directive was to basically demonstrate or reopen the case, but demonstrate a cooperative effort from the division as opposed to a heavy-handed approach by issuing a CO right away. So I decided to just draft up this letter and basically to reopen the discussion of getting a permit.
And this directive, again, kind of lays out the legal framework that Monument Resources needed to step through in order to legally mine limestone at this site?
That is correct.
Okay. Thank you. Turning to Exhibit E, tell the board a little bit about this email.
In response to the previous division, or this division directive in Exhibit D, Ms. Brooke Hedleston gave me a phone call.
Pardon me, this is Exhibit E, is that correct?
Right, we're talking Exhibit E.
Thank you.
Brooke Hedleston called me up and wanted to discuss things, and rather than trying to relay web links and everything to get to our permitting section, I told her I would send her an email with such links. And that's what this email is about, basically giving her the basic information, what they needed to do to conduct any, or to get the permit in progress. And if she had any questions, she could contact me at a later time. But that's the basis for this email from me to them.
All right, thank you. Let's turn now to Exhibits F and G together in the interest of time. F is a partial notice of intent and a check for permit fees. G is a deficiency letter. Will you explain this NOI and deficiency letter to the board, please?
Correct. Well, we finally did get an NOI submitted to the division. In our reviews of these permitting operation or permits applications, we'll draft up a review letter and point out any deficiencies that need to be corrected in the NOI to complete the process.
All right, and referring to the Roman numeral 3, which is page 5 of that exhibit, could you please explain to the board the significance of a couple of these statements in Roman 3, and they go to Ms. Davis's question earlier about the division's jurisdiction here?
Yeah. This is where they describe the minerals being mined as limestone. I believe the limestone name for the mine was originally developed between Tom Munson and Brooke Hedleston, or Monument Resources at the time. And that's where the name of the mine came from, but their primary extraction material is limestone.
And this is important because if it were just sand and gravel, we would have no jurisdiction as a division, right?
That is correct. They are breaking into bedrock and conducting active mining. So.
All right, thank you. And moving on to Exhibit H. Please explain the follow-up to that previous testimony to the board. This seems to be a second NOI.
Yes, this is a second NOI submitted in response to the review letter that we sent them pointing out the deficiencies. What's interesting about this NOI submitted is it really only addresses the deficiencies that were noted in the letter, but it doesn't include the previous information from the NOI. So what we basically had were two packages of an NOI that were two pieces of a jigsaw puzzle that you had to put together to create one. So what I decided to do to save time and get this process moving was I completed a singular NOI with the information provided by the operator, and I created a map for them so that what we had in effect was an NOI package that all they needed to do was sign and resubmit to us and provide a surety and sign a reclamation contract, and they would have been good to go.
And so, still on these exhibits, after essentially all they had to do was provide a surety and sign on the dotted line, did you receive any further correspondence from Monument Resources?
We did not until we sent a reminder letter to them that they needed to complete this process. So,
and how did they respond when they finally did?
Final response we got was not from Brooke Hedleston, but it was from Billy Gaines, who is the owner proprietor of Monument Resources. And what he in effect said was he saw no reason to get a permit from the state for this mining operation.
All right, thank you. Let's turn now to K, L, and N together. That's skipping M as in Mike.
Okay, item K is the cessation order. In response to the email I received from Monument Resources refusing to obtain a permit, we had no choice but to issue a CO to that effect, or indicating that they needed to comply with it.
And you set a date for abatement of June 20th, 2015, is that correct?
We did. We set a date to have the site reclaimed by June 20th, 2015. When that date lapsed, I went and conducted a subsequent inspection on July 23rd, 2015, to verify that the site had not been reclaimed.
And this is reproduced for the board in Exhibit L, is that correct?
Correct.
Thank you. And finally, after that second inspection report confirmed that no reclamation had taken place on site, what was the next step that you undertook, or the division undertook?
In an effort to hopefully get it going before any action had to be taken, Exhibit M was a letter sent to the property owner. This site is located on private property. I did some research with the Salt Lake County Recorder's Office to find out who owned this property, and I sent a letter to them that probably...
Salt Lake County or San Juan County?
San Juan County, I'm sorry. I sent a letter to this Nordine Family Properties, which is located down in Phoenix, to either let them know that there is an illegal mining operation going on their property, they might want to pursue trespass issues, or if they did know the operation was going on, to encourage the person that they knew was operating to get a permit with the state.
Thank you. And then finally, in this set of examples, Exhibit N, November, is an assessment, is that correct?
That is correct.
Explain that assessment to the board.
The assessment basically calculated 30 days at $750 a day for noncompliance, and the total sum was $22,500 in fees and fines.
And for the board's information, the minimum required by statute is $750 a day?
That is the minimum.
And it's division practice, although not required by law, to stop after 30 days?
Yes.
Thank you. Now to finish up, please tell the board if the conditions on site are still substantially similar to what we've talked about here today in the pictures and the exhibits.
Since that last inspection, I have not had an opportunity to go down there, but it is assumed that the site is as you see it in Exhibit A.
We have no information to the contrary?
No, we have not. We have not received any indication that the operator has done any reclamation down there.
And in the off chance that something has gone on, what would the division's proceeding be once we determine that information?
They have conducted reclamation. I believe we could waive the fine on this. If they've conducted the reclamation, then the situation would have been resolved.
All right, so when you get down there in the spring after the snow comes out, you'll be able to take another look.
I will be going down in the springtime to conduct an inspection.
All right, thank you. Finally, do you have any information you can provide the board on how reclamation would actually work here? Is the pretty simple reclamation?
This would be a fairly simple reclamation. As you can see in the gray area on Exhibit A, that's the excavation area. There is some rock that is to the west boundary of that could just be pushed up, and they could regrade that fairly simply and put some seed over it. There was no real topsoil over this area to begin with, so they would have to vegetate the disturbances on the western part, which is in that kind of a dry wash area there, and it wouldn't take more than a couple days.
All right, thank you. Before I let you off the hot seat, Mr. Bradley, please let me invite any questions from the board at this time.
Board members, any questions? I have a few. Let's start with you, Mr. Hanson.
First of all, you mentioned you received an email from, was it Mr. Gaines?
Yes.
Do you have I didn't see a copy of that email.
I think this is directed more towards me. When I compiled this exhibit list, knowing that it would be a public record, I wanted to err on the side of caution because the email isn't, it doesn't paint the operator in a particularly nice light with regard to the authority of the division and the board. So I wanted to do that through testimony, but I'd be happy to submit a supplemental exhibit.
I guess I'm curious as to why he feels like he doesn't have to obtain a permit for mining.
I do have a copy of the email right here. So.
Mr. Chairman, may I approach?
Yes, please. Okay.
Another question that I had, the last time it was inspected, they were continuing to work the operation?
When I was down there, the equipment that you see in the Exhibit A was not there. There was no equipment on site at all.
But it didn't appear that they were continuing to work the mine.
I believe they operated on a batch process. They operated as needed.
And the last question I've got is, if they were to provide you with a reclamation bond and update their permit, would they be allowed to continue working?
We would work with them in that regard and do that, yes.
Thank you.
To follow up on that point, I think that it would not be out of line for me to say at this point that one of the hopes is that a board order will escalate this one higher step towards getting resolution, whether that be through enforcement or compliance. Often operators will take a board order more seriously than a division directive.
If the division does the reclamation here, where does those funds come from? Is there a special set-aside fund, or does it come out of the general budget? Or?
There are funds set aside in these economic times. It can be a little bit of trouble with the accounting office. That's obviously why the bonding rules are in place, but there are contingencies available. And this is a situation where, while I certainly won't represent and tie my client's hands in advance, this is certainly a situation where if state monies were expended on site, my recommendation to my client would be to absolutely go after recoupment of those costs. Again, this goes to one of the helpful things about having a board order is that with a $22,500 fine, the operator is really, it's in his or her best interest to either bond up on the site and go through the proper legal steps to continue mining or to reclaim, because that's a fairly hefty fine that the division can domesticate in civil court.
If I can add to that too, as I understand it, there's a non-lapsing fund that is available to conduct this this reclamation.
Just another thing, is there evidence that they've actually been selling material from the site or just stockpiling it?
No, there is evidence, hearsay evidence, that they have been selling it. I believe that's included in reference in that email that he sent, that they do have, reasons to use this rock. But it's, like I said, it's not a continuous mining process. They mine it as they have a client or a customer to sell it to. So.
Thank you.
I have a question on why the policy is to stop the penalty of 30 days. This particular operator has basically thumbed their nose at you. In industry parlance, told you to go pound sand.
Exactly.
And I don't know why you're being so.
If I can answer, I believe it's
there's an element of leniency here that I don't believe is justified. Would you make a record on that? Because I think the board ought to do something a lot more drastic and a lot more punitive.
Having seen this operation and where he lives and everything, I don't know that he would even be able to pay the $22,000 fine. He's kind of a shoestring operation, so.
Mr. Chairman, if I might respond as well, I think that it would certainly be within the board's authority to increase the penalty. As I said, the rule sets a floor, it doesn't set a ceiling. And I again think in this case it's a question of if a penalty gets too high, then it makes any operator judgment proof against a high penalty. But I think that it's well within the board's purview to review that 30-day sort of guidance that the division uses and direct the division otherwise if it sees fit in this case.
Let me make sure I'm clear. It's within the discretion of the division to get him back into compliance and therefore work with him to a conclusion on this matter. if a larger fine was hanging over his head, wouldn't that be an inducement for him to come into compliance and to put a bond up and not waste this resource?
It would be an inducement to me, for sure. But for him, I've done a little research. He's displayed in other, shall I say, realms or areas, basically a reluctance to comply with government.
Okay.
Yeah.
Understood. We have previously signaled to the division that we are going to be tougher on these small operators who are in non-compliance. Can you give me a reason why we shouldn't send that same signal, not only to this operator, but to small operators in general?
I cannot. The fine assessment was done by our compliance officer. I had no real say in limiting the amount, but that's just been our standard practice, as I understand it, to limit it to 30 days. So.
Any other questions of the board members?
So is there any weakness at all in our argument that this does come under our jurisdiction?
Oh,
that
no.
It is there any weakness in that?
It's solid. They're mining hard
Solid.
rock. It's
Okay.
not sand and gravel. It's a mining operation. So using heavy equipment and potential blasting. So
Back to you, Mr. Robinson.
Thank you, Mr. Chairman, board members. With no further questions, I'll briefly summarize. This case is straightforward with the exception of a few of the questions that board members themselves brought up with regard to that balance between compliance and enforcement. The operator of this mine, Monument Resources LLC, has failed to live up to their end of Utah's permitting requirements. They never bonded the site and indeed explicitly refused to do so. Under Utah law, Rule 647-6-102, failure to post a bond automatically counts as an imminent danger to health, safety, and the environment. The board has the power to authorize reclamation under Rule 647-3-112, and the board and the division also have jurisdiction over all persons and property to enforce the mining laws of Utah, and that's Utah Code 40-8-5. The division therefore requests authorization to reclaim the limestone mine as provided under the rules, and finally the division also requests permission to recover the costs of reclamation and the outstanding civil penalties in Utah Civil Court under Rule 647-3-112 and Utah Code 40-8-9.1. With that summation, I'd also like to move to admit the exhibits. I believe that we did touch on all the exhibits, so that would be admission of Alpha, Bravo, Charlie, Delta, Echo, Foxtrot, Golf, Hotel, India, Juliet, Kilo, Lima, Mike, and November. We could also possibly, if the board would like, to add the email as Exhibit O for Oscar to the record.
I think we'd leave that to you unless the board members feel strongly about it. Does anyone feel like this email you read it that are... Okay. Okay, the discussion was, does any of the board members have a reason why it shouldn't be admitted? I think what we're going to do is mark this as this email, which is really a series of emails, starting with Monday, December 1st, 2014. And it's entitled S/037/0123 Lime Quarry. Will be a new exhibit O, as in Oscar. And so the submission of exhibits would be A through O.
That's correct, Mr. Chairman. I'd be happy to provide an electronic copy to the board and to the board's secretary to make that a part of the digital record in this case.
Okay. Those exhibits are admitted.
Finally, Mr. Chairman, I'd like to move the board to grant the relief either as requested or as modified by the board, and I'll of course be happy to draw up proposed conclusions and findings with whatever the board should determine about, particularly referring to the amount of the civil penalty in this case.
Okay, the case is now to us as the board. Would you like to have a short discussion on it, or do you feel like a motion would be in order?
Maybe a brief, very brief discussion.
Okay, we'll have a brief discussion. Let's just go in the room here for a minute.
Thank you.
Robinson and Mr. Bradley, thank you very much for your presentation.
I do have a question, Mr. Robinson, before we do that.
Okay, question?
You mentioned you contacted the landowner. Does the landowner have any responsibility in this matter?
Ms. Davis, I think that under the laws of Utah, there's no responsibility. It's not like a Superfund type site where you can just tap anyone that has their fingers have touched the site. In some circumstances, if the landowner were working to perpetrate a fraud against the state in conjunction with the operator, I think that would be a different story, but those aren't the facts that we seem to have here. That letter to the landowner was more of an advisory note that says, do you even know if this is going on? This is a family property that's owned by people who are out of state, and so there was some concern that it might have been doubly illegal, both in terms of the surface occupancy and in terms of the Utah law. If that's a answer to your question, I think the short answer is in this case, no, but in some other circumstances, there very well might be liability for the service owner.
Thank you.
Any response at all from the service owner?
We never got any
Nothing at all.
response, no.
You know if they received that letter?
In a roundabout way, I do, in communications with the BLM geologist down in the Monticello office. He indicated that he had heard that this landowner did receive the letter and didn't respond to us for various reasons.
Any indication why?
I think they wanted to try and tiptoe away from it, you know, if I could say that, so.
Okay, board members, we're ready for a motion on this matter.
I would move that we approve the agency action as proposed.
Is there a second to that?
I'll second that.
We have discussed this, so the motion before you is to approve the request for agency action as submitted. All in favor say aye.
Aye.
Any opposed? Let the record show that that was unanimous. Thank you. Mr. Robinson, you will prepare the order on that?
I'd be happy to. Thank you, Mr. Chairman, members of the board, and I will relay to my client, those that are not in the audience today, that the board has reiterated their interest in trying to strike this balance between compliance and enforcement, particularly with regard to fine and civil penalties.
Thank you very much.
Thank you.
We're going to take a break till 1:45. Our next matter will be agenda item number 4, Crescent Point Energy.
I can see, though.
Okay, we are going to go to agenda item number 5 and then come back to number 4. Agenda item number 5 is docket number 2016-005, cause number 222-16, in the matter of Tinto Energy. That matter has been continued until our next board hearing.
Mr. Chairman, is there
Yeah.
any, that stipulation was submitted to you?
Yeah, we have, for the record, on agenda item number 5, the order for continuance has been signed.
We're here to answer any questions you have them, but not.
What is the date? For the record, the next board hearing is March 23rd, 2016, in regard to the Tinto matter.
Thank you, Mr. Chairman. And in addition, there is a stipulation that we were going to move the board to approve in addition to the motion to continue. If you'd like, I can speak to that and explain what the stipulation achieves, or we can just move ahead with the
Why
signed
don't you
order.
explain that?
Okay. So recently, the division found out that Tinto's investors took over the company due to what they viewed as mismanagement of the company, and they expressed an interest in continuing the matter. The division had some concerns given that this operator has been unresponsive for some time now, but we decided to work with Tinto and get the company to agree to perform certain work within a 30-day window in exchange for granting and supporting a motion to continue. So we discussed what could be done with respect to each well within that 30-day window, and came up with the list of work that's attached to the stipulation that you have before you today. Essentially, the stipulation just continues the matter until the March hearing with the hope that we'll come to an agreement on how to resolve all of the issues and eventually won't have to appear before the board again. The stipulation just requires Tinto to take certain action with respect to each well, which includes updating production reports and sundry notices on some, cleaning up the well sites, demonstrating that some of the wells have integrity as required by the rules. In addition, Tinto is going to place $15,000 into an escrow account to be held as additional surety. And then before the March hearing, we plan to work with Tinto to negotiate and agree upon a stipulation for either dismissal or judgment, which will either set a schedule for resolving all of the issues in the notice of agency action, or if Tinto fails to perform the work in this motion to continue and the list of work, providing for automatic entry of judgment against the company, which will achieve what we've sought in the notice of agency action. So we've spoken with their attorney. And we're in agreement, and we advised him that Tinto's attorney did not need to appear today because we were filing this motion to continue. And we're confident that we'll be able to agree on a stipulation for dismissal or judgment. But if we cannot do so, or if they fail to complete the list of work, we'll proceed with that hearing in March. So that's essentially what the stipulation achieved. If you have questions for either myself or members of the division, I'd invite those now.
Board members, any questions? Seeing none, back to you.
Okay, then the division simply moves the board to approve the stipulation and the motion to continue this matter.
To the extent that the order I just signed on the continuance does not include the approval of the stipulation, the stipulation is so approved.
Thank you.
Thank you very much. And now we are to agenda item number 4, docket number 2016-004, cause number 131-142, in the matter of Crescent Point Energy. We'll take appearance of counsel at this time.
David Bolda with Beatty and Wozniak on behalf of the petitioner Crescent Point Energy U.S. Corp.
And Steve Alder with the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Thank you. Any others? Seeing none, to you, Mr. Bolda.
Thank you, Mr. Chairman and members of the board. As you can see, I don't have any witnesses here beside me today, but they're appearing electronically. There they are. I appreciate the opportunity to allow them to appear electronically, especially in these times with the downturn in prices. It makes a difference, and we do thank you for that. So I'd like to introduce the witnesses at this time. Thank you, Mr. Chairman. Board, as you can see, we got an audio problem.
We had a bleed over on that one. Okay. Moment, please.
Okay. My witnesses today.
Hold on, let me get a thumbs up from back here. Okay, we're back to you.
Okay. Witnesses today are Mr. Derek Pym, landman with Crescent Point, and Katie Matthews, Senior Development Engineer with Crescent Point. At this time, I'd like to ask that the witnesses be sworn in.
Proceed.
You raise your right hands, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Let the record show that the court reporter in Salt Lake and the witnesses in
Denver
did raise their hand, and both witnesses did say yes.
Thank you. The resume of both Derek Pym and Katie Matthews were submitted as Exhibit A in this cause. Derek will be testifying as a fact witness only, but as far as Katie, if asked, she would confirm the matters reflected on her resume. As the board is aware,
we're getting some sound bleed over. Could you, in Denver, could you mute your microphones for just a moment?
Yep.
Okay, the bleed over is in Denver.
Okay.
So, could you, in Denver, could you close your door or do otherwise? We're getting background sound from you guys. So we'll need you to somehow lessen that. Am I correct in that? Okay. Say that again.
Chairman, if I could address the remote witness in Denver for a second.
he would like to address the witnesses in Denver to work out the IT issues.
Okay. Please, we'll just take a hold for a minute, and we're going to work with the IT in Denver for a minute.
Denver, if I could have you check your camera, the speakers that you've set up adjacent, if you could separate those speakers a little further away from the microphone, from the camera element. It also appears that the autofocus of your camera has drifted off. You're appearing extremely fuzzy at the moment.
Okay, does that help the sound issue?
Yes, the sound, and we just got clarity back on your picture. Mr. Chairman, if you're comfortable with that, I encourage to proceed with the technology.
Yeah, for future references, I think having an IT expert with the witnesses might be worthwhile, but we'll work through that. Thank you. Mr. Boulder, we're back to you, and we can now hear you.
Okay. Last left off describing that that Katie Matthews has been recognized as an expert in petroleum engineering in a number of different causes before the board, and most recently in cause number 131-141. I would ask that Katie likewise be recognized as an expert in petroleum engineering for purposes of this cause.
Division has no objection, Mr. Chairman.
Board members, she so admitted.
Okay, thank you. I'd like to confirm that the board has received the supplements to Exhibit F and Exhibit G, marked as supplemental Exhibits F and G.
We have received those.
Thank you. I'd also like to confirm that it's acceptable to move for admission of all exhibits at the end of the presentation in chief.
That's our preference.
Thank you. I have a few preliminary remarks before we get into testimony. Crescent Point is the operator of the Gardner State 12-25-32E well located in Uintah County. This oil well is located in an area that historically has not seen a lot of activity. This well and 4 others are the first that Crescent Point has drilled in this region of the Uintah Basin and are therefore still somewhat exploratory in nature. This is a primary reason that the infrastructure is not yet in place to handle associated gas produced from these wells. As the presence of these associated gases that lead to Crescent Point's request before you today. Specifically, in order to continue to test and further produce the 12-25 well, Crescent Point needs to flare associated gases until construction of a pipeline is completed. Utah Admin Code Rule R649-3-20 sets limitations on how much gas can be flared without board approval. Submitted as Exhibit E in this cause, Crescent Point was granted a temporary approval from the division to allow flaring at unrestricted rates until this matter could be heard before the board with limits on the amount that could be flared. Utah Admin Code Rule R649-3-25 sets 20 subsection 5 sets forth the information a petitioner must supply for the board's consideration of additional flaring authorization. Bottom line is that the board must conclude that the gas cannot be put to beneficial use and that marketing or conservation of the gas is not economically viable considering total well production, both oil and gas revenue streams. Crescent Point believes that the testimony and exhibits to be submitted into evidence today will establish just that. Crescent Point has asked for flaring above the prescribed limits until construction of the pipeline to the well can be completed. As you will hear today, Crescent Point estimates that construction will be completed by the end of this year, around December 31st, 2016. Crescent Point's planned pipeline route and pipeline would tie into its other wells in the existing area and the future wells planned for this area to capture all the produced gas from the wells. Currently, only the 12-25 well is producing and flaring gas above the prescribed limits. However, the reason for the delay is that much of this planned pipeline route traverses tribal-owned surface. Crescent Point has applied for the necessary rights-of-ways with the BIA and BLM, but approval is taking longer than expected, as is often the case. Crescent Point will take all steps required under state regulation to ensure protection of the health, safety, and welfare of the general public. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-5-3F and Utah Admin Code Rule R649-3-20, subsection 5. Notice was sent via U.S. mail to all production interest owners in the drilling unit upon which the 2 wells are located. The mailings were sent to these parties at their last addresses disclosed by the relevant Uintah County Realty records. The record will reflect that the mailings were received by all but one of the parties whose forwarding address could not be located. The record will also reflect notice was duly published on February 7th, 2016 in the Salt Lake Tribune and Deseret Morning News, and on February 2nd, 2016 in the Uintah Basin Standard and Vernal Express. The division chose not to file a staff memorandum in this cause, and the State of Utah School and Institutional Trust Lands Administration, who is the royalty owner in this case, filed a letter in support of Crescent Point's flaring request. That concludes my preliminary remarks. At this time, I would like to call my first witness, Mr. Derek Pym.
Proceed.
Derek, can you please state your name and business address for the record?
Of course, Derek Pym, Crescent Point Energy, located in Denver, 555 17th Street, Suite 1800, Denver, Colorado, 80202.
Can you please state your current position with Crescent Point?
Current position is landman with Crescent Point's Uintah Basin asset, inclusive of the lands at issue today.
Thank you. Can you please relate to the board the bonding status of Crescent Point?
Crescent Point Energy U.S. Corp. Is a Delaware corporation in its principal place of business in Denver, Colorado. It is duly authorized to conduct business in Utah and is fully bonded with all the appropriate federal and state agencies.
Thank you, Derek. I believe you have in front of you a hard copy of the exhibits that we will be reviewing today. Is that correct?
That is correct, yeah.
Okay, at this time, I'd like you to turn to exhibits B, C, D, and F in your copies. Were these exhibits prepared by you or Crescent Point personnel with your input and review?
That's correct, yeah. They were prepared by Crescent Point personnel with my input and review.
Thank you. Okay, I'd like to turn to the first exhibit for this presentation, Exhibit B. Derek, can you please explain to the board what Exhibit B shows?
Of course, thanks, Dave. So Exhibit B obviously is kind of a 60,000 foot level reference map that shows the 1225 well that is being referenced by the green arrow on the map. Obviously, kind of a little reference from the cities in Uintah County as well.
Thank you. Now we'll go to Exhibit C. Can you please explain to the board what this exhibit shows?
Sure. So Exhibit C, obviously a little bit more zoomed in version, kind of specifies the subject section 25 that is currently being discussed today. The well is outlined there by the blue shade for your reference. Currently no spacing orders for this location. The location was based off the well sitting rule, approximately the center of 40 acres of the quarter section. This map also references the mineral interest and working interest owners, but I'll get to that in just a second. As the board is aware, Crescent Point Energy currently has a spacing request for the proposed order in front of the board as cause number 131-141. As the proposed order is currently drafted, the order would not affect the spacing or correlative rights of the owners, and if it is entered by the board, if and when it is entered by the board. The order would, however, establish this as a 40-acre drilling and spacing unit for the well, with production allocation being unchanged. The surface of the well is in fee interest. The minerals of the well in the section, in the northwest quarter of the southwest quarter of Section 25 are owned by the state of Utah. Ownership of the 1225 well is undivided and uniform throughout, and production is allocated on a leasehold basis. Exhibit C does also reflect the mineral and working interest ownership in the call-out box. The mineral interest in the northwest quarter of the southwest quarter of Section 25 are owned 100% by the state of Utah and is administered by the state of Utah School and Institutional Trust Lands Administration. The call-out box also references the working interest owners, Crescent Point being a 35% working interest owner. The other 65% working interest owner is Bill Barrett Corporation. There is also one overriding royalty interest owner.
And Crescent Point is the operator of this well, correct?
Correct, yeah. Crescent Point is the operator of this well.
Thank you. Let's go to Exhibit D now. Derek, can you please explain to the board what this exhibit depicts?
Of course, yeah. Exhibit D, obviously a little bit more zoomed out from Exhibit C. It is a zoomed out plat referencing the general pipeline route to an existing tie-in point. The tie-in point is called out in the upper left-hand corner of the Exhibit D. The distance from the 1225 well to the tie-in point is approximately 2.75 miles. As Dave mentioned earlier in his preliminary statements, Crescent Point Energy has applied for the necessary right-of-ways to bring gas from all the wells in the area, including the 1225 well, to the reference tie-in point. Crescent Point Energy is currently awaiting approval from the Bureau of Indian Affairs as well as the Bureau of Land Management, but approval is taking a little longer than expected, resulting in the need to flare for a period of time. The pipeline that is referenced by Exhibit D also does cross a significant portion of tribal land, and thus is subject to environmental and archaeological surveys, including NEPA analysis. Currently, our estimate for the timeline of the completion of the pipeline is the end of December 2016. Obviously, that is very dependent upon NEPA analysis and review and a timely approval by both the Bureau of Indian Affairs offices and the Bureau of Land Management offices. I would also like to make mention that at the risk of setting a difficult precedent for other operators as well as ourselves in the future, Crescent Point Energy has taken the extraordinary steps on deciding on its own accord to pay the royalties on that gas being flared, even though doing so is not required, as the produced gas cannot be marketed due to the lack of infrastructure in the area. Crescent Point Energy at this time plans to do so, to continue to do so, pay the royalties that aren't being marketed up until the pipeline is in place and gas can be marketed at that time.
Thank you, Derek. As a point of clarification, because this might not be entirely clear from the exhibit up on the screen, can you confirm that the portion of the pipeline that traverses the tan, the area that's sort of depicted in tan here, that I'm kind of highlighting with the cursor, that tan area is tribal land, is that correct?
That is correct, yes. That is just a reference for our maps stating that it's tribal land, correct.
Thank you. Derek, with your hard copies, again, this is not an exhibit or a slide, but I would like you to turn to the certificate of mailing, which is a pleading already on file in this matter that was prepared by you. Do you have that certificate of mailing in front of you?
Correct, I do, yep.
Okay. Do you recognize the names on this list?
Yes, I recognize all the names in production as production interest owners of the 1225 well comprised of the northwest quarter of the southwest quarter of Section 25.
And how was this list compiled?
This list was based on a title opinion that was rendered February 25th, 2015, and updated in-house prior to filing the request.
These would be considered business records of Crescent Point, correct?
Yes.
Members of the board, Exhibit F represent, these are the true and correct copies of return receipts received by Beatty and Wozniak of the mailing of the request, which was supplemented last week to reflect the return receipts, or rather return mailing. I believe that was received after January 25th, 2016, the exhibit filing deadline. These will be proffered into evidence at the end of the presentation in chief. All but one of the parties received the mailing. That one was returned as undelivered, and no forwarding address could be located for that party. Mr. Chairman, this it concludes my examination of Mr. Pym.
Just to be clear, we have Exhibit F and the supplement to Exhibit F. Are you going to include those as both being the attempts to contact
yes,
interest owners in this matter?
Yes, both Exhibit F and supplement Exhibit F.
Thank you.
Yes.
Okay. To you, Mr. Alder.
Thank you. Mr. Pym, is that right?
Yes, sir.
I do have a few questions, and I think it would be helpful to just pull up Exhibit D and refer to it to answer some of these questions.
Okay, I have it in front of me.
Thank you. The particular well that is producing is one of 6, I believe the testimony was, that were drilled in this area?
Yes, sir, that's correct. Oh, excuse me, 1 of 5.
1 of 5, okay, and the most likely to provide evidence of future production from this area. Maybe I'm quoting from the request, but that's what I recall from this matter. Is that right?
Yes, that is correct.
Do you know where the other wells are located? Can you show us on this exhibit or describe?
Yes, sir, yeah.
Okay.
On your Exhibit D, you can see section 27, 3 south, 2 east. I'm just using that as a reference.
Yes.
So obviously section 25, 26 would be just to the east of that. We do have some some drilled locations in the south half of that section. We have 2 pads currently in that south half of section 26.
Thank you.
We also do have in section 26 the northeast quarter of the northeast quarter. We have some producing wells, one producing well in the northeast quarter of the northeast quarter of section 26. If we go a little bit further south, you can see the reference number 35. I'm going to jump over to section 36. We have a producing well in what would be the northwest corner of the southwest corner of section 36.
Thank you. And are all of those wells shut in? You said they were producing, so I guess they're not shut in.
They are producing, correct. They are producing at this time, correct. Yes, sir.
But they are not in need of any order. Are they flaring at all?
They are not in need of any order. They are flaring, but below the limits.
And I assume you have the lease for the Gardner property identified in section 26 and a surface use agreement?
Yes, sir, we do. So that property is, we have a surface use agreement for all of those wells. That's correct.
And does your surface use agreement allow you to construct a pipeline across the property?
Yes, the pipeline was considered in the surface use agreement, and the pipeline is represented in the surface use agreement, correct.
I'm wondering why you chose the route you did. It seems very circuitous to get to the existing infrastructure to the northwest, it appears, and outside of section 21, I guess that would be.
Yeah, for the tie-in point in section 21. The route was chosen on a number of aspects. One being we have a number of planned wells west of the reference 1225 well. Obviously, there are some points to take in to bring all the wells together. Going to the east, you can see there is in section 19, 7 south 20 east, that is BLM land. Or no occupancy surface stipulation. It'd be very difficult to lay a line across there.
Right, but there's no reason to go east, right?
I beg your pardon?
Is there a reason to go to the east if you're trying to tie into the northwest?
No, there's no reason to go to the east if we were trying to do that. Also, our tie-in point is to the west there, so it essentially make more business sense for us to go that direction.
And is the current status that you are still trying to get right-of-way approval?
I apologize, say that again, sorry?
Are you still trying to get right-of-way approval?
Yes, sir. The right-of-way approval is, we have applied for all the necessary right-of-ways. We're just awaiting approval from the necessary agencies, which have to do all the NEPA analysis. One thing I also would like to point out is our tie-in point. We do have there is a significant river. We do have a river bore well that will connect to a lot of our infrastructure, which is west of this map, but a number of Crescent Point Energy wells in that area.
So where the map shows the tie-in to existing infrastructure, is that not the point of tie-in?
Sorry for the confusion. That is the point of tie-in. That is close to where the river bore would be, which connects a lot of our western wells to this eastern area.
So is a river bore shown on this map?
It would not be shown on this map, no, sir. That is, but that is our tying point. That point there on the map where it's called out is constructed, and that is just east of where the river bore would come out.
And as the river bore is not constructed yet?
The river bore is constructed.
Oh, that is completed. Okay.
That is completed. Sorry for the confusion.
No, it's helpful. And are there NEPA issues of a particular unusual sort that affect these lands in this right-of-way application?
To my knowledge, no, they're not of an unusual circumstance to these lands. Unfortunately, I think we're just under the stipulations of the NEPA analysis, and from time to time they do take some time to do those analysis. Obviously, that it is traversing across a significant portion, so there could be a lot of analysis that have to be taken place here.
I guess that was kind of leading to my overall reason for these questions is, are there endangered species identified in any of these tribal lands?
To my knowledge, no. And I think that, well, there are cactus, excuse me, there are cactus in the area, so that would lead to a part of the analysis there.
Would it be feasible to connect directly from the well going west to the line that you show as being the proposed route? And would that get this pipeline constructed quicker?
If we were to traverse across the fee owner's property?
Yes.
The part that crosses section 22, section 27, and section 34, that does parallel a county road. You can also see there, it's not necessarily clearly referenced in this map, but there is a very big irrigation pond that the landowner uses, which is directly west of our 1225 well. In an effort to work with the landowner, this was a route that is an existing 2-track road along their property, and a good spot for the landowner and Crescent Point Energy to place the pipeline.
And I guess that's my question is, assuming other factors such as satisfying the landowner using the existing road were not in play, and your goal was to connect as efficiently and as quickly as possible to preclude flaring of excess gas, is there any reason you couldn't just go directly west from the well to the point shown there across the south part of the Gardner property?
Well, with the wells that are in the south part of section 26, there is a planned pipeline route that would still go out to the planned county road, which is the gray line. Not the county road, but the pipeline that is referenced there. So we do have a pipeline planned there. The irrigation pond was kind of a big hazard that we had to take into account, which is just directly west of that 1225 well.
Right, and I'm not trying to suggest how you do this. I'm just asking the question of whether, since flaring is currently a board order is required to allow flaring right now because it's exceeding the amounts allowed under the Utah rule, and the longer that goes on, the more flaring there is. There's some advantage, at least as far as avoiding excess flaring, to get this pipeline in place. And did you look at the alternative of going, because it looks like you can go around the pond and then where the existing right-of-way shows a route to the west, just continue directly west? Did you consider that option, and why did you not accept that option?
I think the part west of the 1225 is still under the NEPA analysis. So the portion of pipeline that is in section 27, 3 south, 2 east, because this has a tribal connection or a federal connection, that is still under the NEPA analysis, and that pipeline could not even be constructed at this stage just yet. So we would still have to get the approval from our right-of-ways for that line that is in section 27.
Okay, and there's nothing about shortening the amount of or tribal lands that that would make it go faster?
Unfortunately, no, sir.
Okay. That was a lot of questions for that. I'm sorry.
No, thank you.
I think that's all the questions I have, Mr. Chairman. Thank you.
Board members, any questions?
The decline curves that were provided don't seem to have a scale on them for the gas volume. It's just got in barrels per day. How much gas is this 1225 producing currently?
We will get to that with the next witness. The next witness will be Ms. Matthews, who will address those numbers at that time.
Yeah.
Okay. Mr. Moon.
My questions are along with Mr. Alder's questions that I hate to extend very much, but just to second guess what you've done any more than he already has. But just to the west, there's some Finley wells and some Bill Barrett wells that must have gas lines to them. I was just wondering if you had talked to them about, at least in the short term, tying into those lines. There's some Finley wells in section 36 and some Barrett wells in 29 and 32 just to the west. Any thoughts or conversations that went on there?
So I can speak to a little bit of the wells. There obviously there are a number of factors involved with tying into other operators. Our teams have looked at some of those options, but some of those factors of tying into other operators might not necessarily be as economical. There are some other flared wells down in this area, so I can't speak to how some of those other operators are dealing with some of that, but the discussion of potentially tying in has been discussed, and unfortunately there's some other factors with tying into other operators that have to be taken into consideration there.
Thank you.
Any other questions, board members? Then back to you, Mr. Bolda.
I don't have any further questions for Mr. Pym. Thank you, Derek.
I do have one more question, Mr. Chairman. I meant to ask it before, and it's just a question as to the status of the state lands. If I could ask that, I apologize. Okay, thank you. On the land status deal at the bottom of your map, it identifies as blue state lands, but I didn't see any blue on the map. Are there any state lands in this area? I thought you said there were on direct, but I just didn't see them.
The surface, are you asking the surface, sir?
Either way, surface or maybe that's...
The minerals are state minerals in section 25. 3 south, 2 east. Obviously, that's the well reference there is drilling into state minerals. In this particular area, there are no state surface.
So the state mineral is section 25?
Yes, sir. The state mineral section 25, the northwest of the southwest quarter of section 25, is drilling into a state of Utah lease.
Only the northwest, southwest quarter of section 25.
Okay, and it's not marked on here because this map just shows the surface status then?
That is correct. This map is just a surface map.
So it's that sort of triangular piece where the well is. All right, thank you.
That's correct. Yeah, Exhibit C has the zoomed in portion of that section 25, and it's outlined in the red.
Thank you. Thank you, Mr. Chairman.
Thank you. Okay, call your next witness.
I'd like to call Ms. Katie Matthews. Can you please state your name and business address for the record?
Sure, Katie Matthews, and it's Crescent Point Energy at 555 17th Street, Suite 1800, Denver, Colorado 80202.
And your current position with Crescent Point?
I'm a senior development engineer for Utah.
Thank you.
Fix the camera.
Your camera's out of focus again.
Sorry about that. We'll get this.
There we go. We just have to move a little and it comes back.
Yeah.
Thank you. Katie, I believe you also have a hard copy of these exhibits in front of you. Is that correct?
Yes, I do.
Okay, can you, at this time, please take a look at exhibits G, H, I, J, and K? Were these prepared by you or Crescent Point personnel with your input and review?
Yes, they were.
Thank you. We'll now turn to exhibit G and supplemental exhibit G. Can you please explain what exhibit G is and the need for submitting a supplemental exhibit G?
Sure, so I'll speak to the supplemental exhibit G. This is basically a production plot of rate versus time. The green line is oil in barrels per day. You can see at the bottom it has barrels in the parentheses. The blue line is water produced, so barrels per day, and then the gas is MCF per day. So that's in the brackets, and it does correlate with that y-axis on the left. So just note that this is rate versus time. You can see all three lines, the oil, water, and gas, are declining over time. So we're seeing that shallowing, that pressure depletion of the field. As of February 21st, 2016, the 1225 well has produced 30,720 barrels of oil, 9,390 barrels of water, and 21,724 MCF of gas from 8 fracked stages in the Lower Green River and the Wasatch. The 1225 is currently producing at a GOR of 1,200 scuffs per barrel. And as of Sunday, the well is pumping at 80 barrels per day of oil, 15 barrels of water per day, and 100 MCF of gas per day, with a more precise GOR of 1,267 scuffs per barrel. So as to that gas number, that equates to about 2,900 MCF for the month of February. So as I already mentioned, you can see that those rates are decreasing over time, and there is a possibility that the well could very well fall below the 60 MCF a day threshold.
Thank you. Now let's move on to Exhibit H. Katie, can you please explain to the board what Exhibit H is?
Sure. Exhibit H is just a readout of a gas analysis that we had performed on the well. You can see at the top the title of the well is on here, so the Gardner State 1225-32E. The guys performed this analysis in November of 2015, and essentially it just shows that this well is predominantly natural gas. So you can see the top buckets are methane, ethane, propane. You see 0 H2S, which is great, and then very low greenhouse gas. So just a typical natural gas profile.
Thank you. What is the current status of the flaring at the well?
We are currently flaring. We use about 10 to 20 MCF per day for the well itself, and then the surplus is flared. The flare is 125 feet away from the wellhead and tanks.
Thank you. I would like to backtrack one moment on Exhibit G and Supplemental Exhibit G, because I'm not sure I made the point clearly. Katie, can you please explain? Exhibit G was production through the end of December, which was submitted in January when the exhibits were due. Is that correct?
Yes.
And then the Supplemental Exhibit G included the production for January to give an update on where things were at a more recent date. Is that correct?
Yep, exactly.
Okay, thank you. Now I'd like to move to Exhibit I, if we could. Katie, please explain to the board what this exhibit represents.
Sure. So this is just a decline plot that helped me estimate what the well will ultimately recover. So again, this is rate versus time, rate on the y-axis, time on the x-axis. The green profile is oil production, the red is GOR, the blue is total liquid rate, and the brown is your oil cut, so your percent oil. Basically, you just need to look at the dotted blue line that I've forecasted, and I used a B factor of 1.178. a final rate of 2 barrels per day, and an EUR, or estimated ultimate recovery, was forecasted out at 130,000 barrels. The GOR that I used, it changes over time. At the time of forecast, it was 1,000 scuffs per barrel. That would have yielded similarly a 130 million cubic feet gas EUR. At the now higher sort of 1,200 scuffs per barrel, that's more like a 156. We will have this well tied in, so that's a non-issue, but I just wanted to show those as the ultimate sort of MBOE recovery.
Thank you. Now I'd like to turn to Exhibit J. Can you please explain to the board what this exhibit shows?
Sure. So I'll just build on what Derek was speaking to before. Basically, the pipeline permitting is in process. It's complicated due to the fact that it traverses tribal. We have cactus issues. We have wetlands issues. There's also a portion of a pipeline that was proposed to be buried in a highly trafficked road. Crescent Point is not willing to take that business risk, so we wanted to tweak that. So there's a lot of moving parts, and we want to do this right the first time, hence why we're waiting to have a properly permitted pipeline. So some alternatives to flaring would be things like gas reinjection for storage, gas reinjection for EOR or enhanced oil recovery, electrical generation, things like you power a generator and essentially sell power back to the grid. All of these methods are very capital intensive, and they would require years of permitting. So our fastest method is just to wait and tie these into our existing infrastructure. Right now, I already mentioned the well is producing 100 MCF per day. We're using 10 to 20 MCF per day, and that's to power things like the pump jack, the treaters, and keep the burners on our tanks fired up. So that's the typical lease usage. And then I already mentioned at the bottom, our preferred option is obviously to tie the well into our previously constructed river bore. We finished that in Q1 of 2015. We're just waiting on final NEPA and permit approvals, and then we'll kick off material ordering and construction. It is a very expensive pipeline, I'll be honest, and it's going to take a while, but we're excited to get these wells tied in and start gathering some revenue on the gas side of things and NGL.
Thank you. Now on to Exhibit K. Could you please explain this exhibit for the board?
Sure. So Exhibit K, in addition to the fact that we're waiting for the pipeline, there is another alternative, I suppose, of shutting in the well. We do not want to proceed with that. It's the best well of the 5 that we've drilled on the east side of the river. And there's also a risk. There's always inherent risks that when you shut in a well, you may not get it back. It could be scaled up. Our waxy crude could have issues. There's also capital associated with shutting wells in. If you're shutting a well in properly, you need to fill the annulus or the backside with scale inhibitor. You also need to then spend capital to bring the well back on, things like rig work, hot oil jobs, wax knives, things like that. So we're also not 100% working interest. BBC obviously has 65% working interest, so they would like the well to continue producing. We had a letter of support from SITLA. They would also like the well to continue. And there is that inherent risk that the well could have issues upon bringing it back online. Derek mentioned finally that we are paying royalties on the flared gas volume, sort of as a good faith measure, and we will continue doing that into the future until it is tied in.
Thank you, Katie. Then in your expert opinion, do you believe that the gas cannot be put to beneficial use and that marketing or conservation of the gas is not economically viable considering total well production?
Correct, yes.
Is it also your expert opinion that flaring of the associated gas until the estimated December 31st, 2016 pipeline completion date is the only technically feasible and economical option for the well?
Yes.
Thank you, Mr. Chairman. This concludes my examination of Mrs. Matthews.
Thank you. Mr. Alder, could you give us an estimate of how much time you think your cross-examination is going to take?
Mr. Doucette has a couple of questions. I would like the witness to address some of the same issues that I asked the previous witness. I'd say 7 minutes at the most.
Would the witnesses be available if we took a recess now until 1 o'clock?
That's fine.
Yes.
We
I
have
hate to-
another matter that we need to address.
Yeah, and this is the last matter. I hate to delay it. I don't know if the board has interest in, the concern I have is whether the applicant or the Crescent Point considered the alternative of a shorter route and why they rejected that. That's the most crucial question I have. I don't know what questions Mr. Doucette has.
And we'd like to hear those in detail. We're just trying to get a lot of things done in a short period of time before Mr. Hanson has to leave. And he has been involved in the matter we're going to discuss for 2 months, and we need his input. So I think with that, we are, if board members, we can continue on it, but I would recommend that we take a short break and that we will reconvene at 1 o'clock so that the division has the time that it needs for cross-examination and otherwise. So with that, board members, we're going to go into this little room here. We are in, going to take a break until 1 o'clock. We intend to be in the other room before 12 to start the other meeting on the working lunch, just so you're aware. And the reason we're using this room is so that you can set up lunch in that other room. Any questions with that? Okay,
No.
Then we will be in recess until 1 o'clock.
Thank you.
We'll make it.
I think that little picture.
We're back on the record.
Yeah.
Thank you for accommodating our busy schedule today. The last place we were at was to ask the division if they had any cross-examination beyond what they had.
That's correct, Mr. Chairman.
Okay, no questions, then.
No, no. That's where we are. I do have some questions. That was a joke when I said I didn't have questions.
We just wait an hour and a half and you have no questions.
Doucette had a couple of questions, and then I have some that I'd like to ask as well. So if we could start with Mr. Doucette.
That'd be fine.
If you'd turn to Exhibit G, the supplemented. So Katie, on this, the new data shows that gas production has increased a little bit. Can you explain the reasoning on that?
Honestly, I can't. The only thing I can think is that you'd almost look at it like a plateau. The down dip, I don't know. I would just, this is daily data, so it's quite sporadic. So I would just look at it more that it's a plateau at 100.
So still kind of on the general trend decline that you saw before overall?
Yeah, I think like the gas started at about 180 and it was declining, and it's now plateauing because I think at the same time you're seeing your GOR increase. So while your oil and associated gas looks to be decreasing, your GOR is starting to increase because you've hit bubble point. So we'll probably plateau for the next little while, and then as you blow down more and more gas, oil, your gas should come down too.
So in this well in particular, do you foresee any additional completion intervals or potential?
I don't right now, especially at $30 oil. If the geologists find that some stringers in between are desirable or going higher, maybe into the R4, there could be recomplete potential. So there's a possibility that gas could pop a little bit more, but it's not on our radar right now. We drilled 2 other wells in Q4 of 2015 and completed those the way this well was, similarly to how this well was completed. So I don't see us going in anytime soon.
Okay, so probably not before you get this connected to the gas line.
Correct, yeah.
Okay. You turn to Exhibit I.
Mm-hmm.
So on this, I know you don't have the decline on the gas pictured here, but could you tell me, based off of, kind of hard to do decline on this, I guess, but where you're thinking it will cross below the allowable limit for the well?
For the 60 MCF.
For the 60 MCF per day, yeah.
So, like as I just mentioned, it's hard because your oil's declining, but your GOR is climbing. So I would have to plot that out separately. We're at the 100 MCF per day, and there will be a threshold where the gas ultimately starts decreasing, but I would have to plot that out separately. I hope that it's soon. I did like total monthly volumes. It's been dropping like 300 MCF per month kind of thing. So if it continues that way, we'll be under in like 4 months if it continues dropping.
Okay, but there's some variance there. It may or may not, but
there is, with the GOR increasing at the same time. So
okay, those are the questions I had. Thank you.
Thank you, Mr. Alder.
Thank you, Mr. Chairman. So, Ms. Matthews, just following up on that question, is the requested variance to the rule limited in time, or just for the duration of this well? In other words, the request you're asking for.
Would you speak closer into the mic? For some reason we're not picking you up.
I'm sorry, yes.
Thank you.
The question is, and I probably should know this, but are you requesting that the board allow you to flare for an unlimited time, or I believe it was terminated in December, is that right?
Yeah, correct.
So, and you believe that by December you'll be below the limits then, based on
Or,
this?
or tied in.
Or tied in, okay. Would you turn to Exhibit J, please?
Okay.
Down at the bottom where you talk about the gas pipeline, the preferred option, you indicate that Crescent Point constructed the river bore in first quarter of 2015. Was that in anticipation of these wells on the other side of the river?
Yes, we were setting ourselves up for East Randalet development. That river bore had years of permitting associated with it. So we got the approval and we built the river bore. It was about a $4 million project. And luckily we did that in late 14, early 15, got it under the radar. So.
And when did you get authorization from the landowners and apply for the right-of-way for this gas line that you have proposed?
I might let Derek ask that or answer that. That's a bit more of a land.
Is that, it's not a problem for me, Mr. Chairman?
No, go ahead.
Okay.
So to answer the questions, you're asking, do we have the right-of-ways approved by the landowner?
When did you first get approval from the landowners, and then when did you apply for the right-of-ways from the BLM that are currently holding you up?
So the application for the right-of-way was started prior to the approval of this pipeline route on the private land, on the fee landowner. We had started negotiations with the fee landowner at that same time. This was a back and forth negotiation.